in today's technocratic world, everything is about data. Hi, so today's topic for editorial discussion is Dangers in Digital Data Protection Bill 2023. So recently the cabinet has approved the Digital Data Protection Bill, all these things, and it has soon it will be placed in the parliament session and all these things. There has been a lot of apprehensions with respect to the bill. A lot of people have criticized the bill on various accounts. Some are citing the bill is too secret. There is very much secrecy is maintained in the bill. There are varied varieties of criticism placed on this particular bill for personal data protection. So we'll see what are the key features of the bill, what are the significance that the bill holds. Another thing is that what are the issues, three major issues that are being cited for criticizing this particular bill. So yes, when it comes to data, yes, in today's technocratic world, everything is about data. Data is being used as a commodity. It is being used to build data. It is used to build apps. It is used to build services and all these things. It is used to build customer preferences, to send us targeted ads, and all these things data is being used. So data has become a very big commodity in today's world. So when it comes to data, there are two types of data that has to be noted. One is the personal data, which this bill deals with. Digital Personal Data Protection Bill. This is the Digital Personal Data Protection Bill and non-personal data. Now what is personal or non-personal data? So when it comes to personal data, the thing is, if the data can be used to identify a particular individual, then that data is called as a personal data. If the data can be used to identify a particular individual, then that data is called as a personal data. For example, we'll take the example of Mr. X. Mr. X orders through Swiggy or Zomato. He gives his name, he gives his email ID, he gives his mobile number, and he also gives his address. So by tracing the email ID, address and mobile number, I can find who Mr. X is or where Mr. X lives. So this is personal data. With the data that I have, I can easily trace Mr. X. So this is personal data. When coming to non-personal data, it is the opposite of personal data, where the data cannot be used to pinpoint a particular individual or cannot be used to find or seek out a particular individual. The same example, let us remove the number, name, address and email ID of the order, so someone who placed order, right, of Mr. X. The thing is, we all know that someone from this particular place, we'll take Anna Nagar has ordered so and so food from so and so place. So in the first instance, I could have easily targeted that this is Mr. X. He has ordered chicken biryani from Dindikal Talapagati and he lives here. This is his mobile number and this is his email ID. So that is personal data. But now here, I don't know what he has ordered. He has ordered something from a particular area. So I'll say he has ordered from Anna Nagar. He has ordered from Anna Nagar. He has ordered so and so food from so and so place. So here I cannot pinpoint who Mr. X is. So that is what non-personal data is. So this particular bill, it talks about digital personal data protection. It talks about digital personal data protection. It does not talk about non-personal bills. So yes, digital personal data, there have been two instances when it comes to this bill. This is the second instance this bill has been introduced. Earlier in 2019 a bill was introduced, but it was later withdrawn. Yes, in 2017 Supreme Court in the K.S. Puttasamy case has given this verdict. It has made right to privacy a fundamental right under Article 21. Yes, in 2017 government is instituting a particular committee on data experts known as the headed by B.N. Sri Krishna committee. So this is what the committee is named as, the data protection, for data protection, all these things. This committee is submitting a report on July 2018, and in pursuance of the recommendations of the committee, a new bill has been introduced. A new bill has been introduced in 2019 and it was open for public review and all these things were happening. Later in 2022 the bill was repealed. It was withdrawn from the books. And later in November 2022, another bill termed as the Digital Personal Data Protection Bill 2022 was introduced in November 2022 for public opinion. And this is the bill that is going to be tabled before the Parliament in the upcoming days or matter of weeks. So yes, This is what the article is. This is how the bill traces its origin also. In fact, before this, we did not have any provisions for data protection. We only have certain regulations in the Information Technology Act of 2000, but these provisions or these regulations, they were not adequate to ensure data protection. So that is why we need a more generalistic or more particularistic bill on personal data protection, that too digital personal data protection. So yes, now we'll see the key features of the protection bill, data protection bill. So yes, applicability. So who does this data protection bill is applicable to? Who does this bill apply to? So it is applied to data processors. So data processing, in the sense, it is a process. Data processing is a process that deals with collection, storage, usage and sharing of the collected data. Collection, storage, usage and sharing of the data that is collected. So this particular bill, it is applicable to data collected through online. It is applicable to 3 instances. Within India, 2 instances, and outside India in 1 single instance. So within India, there are 2 instances. If it is collected online, it is applicable. Then if it is collected offline but later fed into digital format, or it is transformed, it is digitized or it is transformed into digital format. These 2 applications, these 2 instances, it is applicable within India. And outside India, if the data is being used or the data is being processed for a good or service to be sold in India, for a good or service that is to be sold in India. Yes, we build apps and we build programs using data that can be used everywhere, right? Yes, even in a foreign company can use Indians' data to build apps that are specifically made for Indians. So this is what the third instance is. It is also applicable to those who collect and build information outside India for the uses in India, for the use or sale of goods and services in India. So this is what the applicability of the bill is. So next is the consent. So it is a consent in the sense, this data processing can be done only with the consent of, only for lawful purposes, but it also has to be done with the consent of the data principal. Now who is the data principal? If my data is being used, I must give the consent. So I am the data principal there. So that is what the data principal is. If my data is being used, I must give the consent, and I am the data principal. If your data is being used, you are the data principal. So all these things are there. So consent of the data principal. Data processing should only be done for legal processes and only for legal purposes, and this also needs consent from the individual, from the data principal. Yes, in certain cases, consent is deemed to be given. Consent is deemed to be given in the sense they will not personally ask for consent, but it is deemed to be given. For example, when there is issue of public interest, when there is national emergency issues and medicinal emergency issues and all these things and all, we cannot run around to people and asking for consent letters and consent forms, right? So in these instances, consent is deemed to be given. So yes, that is what consent is all about. And the third key feature of the bill is that of rights, duties of data principal. We know who a data principal is. The person whose data is being processed is known as a data principal. Now he has certain rights. Certain rights in the sense, he can ask for how this data is going to be used. He has this right. He has the right to grievance redressal. If there is any issue, we can redress that issue. And he can also call for removing of data. You can also ask for removing of data or erasure of data or correction in data given. These are the rights that are given to the data principal. He can also withdraw consent whenever he finds. Necessary. So these are the rights given to the data principal. Now what are the duties? Rights comes with duties, right? Yes. Duties of data principal is that duties of the data principal is that he should not make any false complaints. He should not give any false data. So if data protection, if you are infringed in some way of your rights, you can go file a complaint. But that complaint, it should not be false or frivolous. So that is what the first duty is. No false or frivolous complaints, and suppression of data or false data should not be fed into the system. So these are the duties that the data principal has to follow, and in case of failure, he is subject to a maximum penalty of rupees 10,000. is subject to a maximum penalty of rupees 10,000 if these duties are not done or not considered. Next is the transfer of data outside India. Yes, the central government has the power to name a few countries where data can be transferred and data can be processed outside of India also. This is the power that central government has imposed on itself through the Digital Personal Data Protection Bill, transfer of data outside India. So yes, next the Data Protection Board. The bill also envisages or also aspires to build a particular body, a board, in fact a board to take care of all these data protection issues and all. So that particular body, a statutory body, is the Data Protection Board of India. The Data Protection Board of India. So this is the fifth major feature, and the sixth major feature and the most controversial and one that is subject to various discussions and deliberations is that of the exemptions. Exemption in the sense the central government can in certain places give exemptions to the functioning of the bill. So what are these instances is that it can give exemptions when it comes to public interest. Public interest in the sense it has a very wider ambit. We cannot we cannot explain what public interest is. Public interest can bring about national security issues. Again, there are a lot of public order, there are a lot of other issues that can be brought under this particular ambit, this particular terminology of public interest. So yes, that is very wide, and that is why it is being variedly criticized by various experts. Exception number 1 is for public interest, and exception number 2 is for research purposes. Research purposes also exemptions can be given. So these are the key features of the Digital Personal Data Protection Bill. Now what is the significance of the bill? We will move on to the significance. What is the significance of the bill? What does this bill achieve for us? The first thing is that it fills the gap and strengthens data protection. We saw that only provision for regulation of personal data is in the Information Technology Act 2002. That also is not sufficient. That will not ensure adequate protection of data. So this is there. So we have seen there are a lot of attempts being done to be in fact to be exact. So yes, this shows us that there is a legislative gap when it comes to data protection, and this particular law, it seeks to fill this gap. It seeks to fill this lacunae by giving us a very good or a most suitable legislation for data protection. And this also strengthens data protection. Yes, we have seen all these provisions. There is consent related issues, rights of the data principle, and all these things are there. It also strengthens our data protection regime. Builds consumer trust and confidence. So builds consumer trust and confidence in the sense people, when they are sure that their data is being protected adequately, that their data is not being used by other third parties. And yes, data is very important. Data can be used for malicious intents or various other crimes also. Identity theft can be done, your data can be removed, and financial crimes can be done, and all these things can happen. So yes, when the consumers, when you and me and other common people are sure about the data protection regime of the government, this boosts the trust and confidence of the people. They will outrightly come and they will, without any fear, they will indulge in transactions and all these things. So that is that builds consumer trust and confidence. Next point is that accountability and remedies. Accountability and remedies in the sense when there are particular data breaches in the sense the data is getting compromised, data is getting hacked into, the server is getting hacked into, and data is getting transferred somewhere and all these things. So in times of this, in times of these instances occur, the rights, that is the data principal, has to be informed that this so and so has happened, and this data principal has the right to seek legal remedies. He can go ask why this has happened, he can redress his grievances, he can raise his issues and ask for resolving such issues, and all these things can happen. So this is what remedies is. So the existence of the remedies, it brings more accountability to those who protect data, or these data fiduciaries, those who collect data repositories. It gives them more accountability. Only because when such a breach happens, or when such a breach occurs, people can go to the courts, or people can go to the appropriate authorities for remedies. So this gives them more accountability. So yes, again, trade relations, yes, this might seem a bit comical, but in fact a true reality. The thing is, a lot of other countries, especially the West, and within the West, the EU, European Union, they have constantly cited issues with our data protection regime. Some countries, they have a very strong data protection regime, especially European Union, they have very strong data protection regime, and they cite that India's data protection regime is not up to the mark, at least not up to their mark. So yes, so they want much more significance or much more complex legislation for data protection, and when this bill becomes an act, when this bill comes to fruition, trade relations can also be improved between European Union and India. So that is one possibility that can happen, trade relations, and harmonizes data protection and national interest. So yes, we have seen data protection, yes, data protection can, yes, it is a very good thing, has to be protected, but on the other hand, there is also this issue of national interest or this public interest. So this has to be balanced out. So what this bill does is that it provides exemptions in certain cases. The data protection, in most cases it is data in most cases is protected, but in some cases, just like national interest and all these things, it is yes, it is not protected, and national interest is placed before data protection of the data principle. So it strikes a perfect balance between national interest and data protection of data principles. So that is another significance of this particular bill, the Digital Personal Data Protection Bill 2023. And what are the issues? So what are the issues of the data protection bill, personal data protection bill? Threat to transparency. What is this threat to transparency? So yes, the primary objective of a data protection bill, what is the primary objective? It is to protect the data of data principles. So yes, now who is the largest repository of data? Largest repository in the sense, largest storage place of, we'll say repository will substitute with warehouse. We'll say who is the largest warehouse of data? It's the government. So what this bill does is that it gives more power to the government. The government can cite exemptions. There are a lot of exemptions. Public interest is just a vague terminology that can be cited for a very lot of things. Can be cited for a very lot of things. So yes, so that is one big issue. There is no transparency. The primary objective is to protect data, but this cannot be done due to central government having humongous powers when it comes to exceptions and all these things. So this does not have transparency. So that is what critics place on the bill. There is no transparency, and government has a lot of restrictions and all these things. In fact, the government can also exempt certain government and private agencies for their sake. For their sake in sense, UIDAI, the data protection law will not apply for UIDAI, or other private sector also. For example, we will take Adani Group. So data protection will not apply to the Adani Group. But yes, there is a possibility that cronies also can get indulged, can be pulled into this exemption fiasco. So yes, again, dilution of DPPI. So DPPI, Data Protection Board of India, has been set up to protect the data of people. Yes, this has to have some sort of autonomy, right? It has to have some sort of autonomy, but there is lack of autonomy, there is dilution of the powers of DPBI, that is the Data Protection Board of India. The thing is, a lot of people, what they said is that this has a very large power. DPPI has very large powers, but the thing is, it has been hampered down, or it has been tied to a rope and linked to a leash. It has been linked to a leash with the central government. Thing is, any sort of appointment, any sort of jurisdiction, all these things, it comes under the central government. So there is a possibility by appointing a chairman of this DPPI, the central government can control the data protection of individuals or the data protection bill in general. So this can happen. So dilution of the DPPI, and the issue of RTI, right to information. So we all know this, we have this Right to Information Act, right? So through this Right to Information Act, people can seek out information, and this is a very good act, and in a lot of other cases also it has helped people a lot. So yes, this data protection bill, it can contradict with RTA. So that is what critics place. So government can cite data protection and not give RTI to people, not give information to the people who seek them. So this is another issue that is being cited by this particular by critics on this particular law. So these are just basic laws, and as seen earlier, we not know what are the issues, or the bill is being kept in secrecy, right? What are the issues that is being followed. Once the bill gets stable and it comes out for public review and all these things, we'll know what are the exact issues that the bill faces. Thank you.